The next thing I want to talk about is what is a short sale. Well, if a loan modification doesn't work, and typically, loan modifications can work, but and still result in a payment that doesn't necessarily work for the homeowner. So a lot of times I tell homeowners, look, if you're severely underwater on your house, if you're $150,000-$200,000 underwater on your house, you got to ask yourself a question: is the lender willing to modify your loan into a payment equal to or less than you could pay for rent on that house? If the answer to that is no, and they're asking you to pay more than you could pay for rent, and that payment, and they're not willing to reduce the principal, which means you're still underwater on the house, it really doesn't make a whole lot of sense for you to maintain that property. Sometimes people get emotionally attached to the property, and they'll try to do a payment that is above and beyond what they can afford anyway, but ultimately they'll probably end up back into delinquency status, and they'll be right back to where they started from. So I always tell people, look, if they're willing to modify you into that payment that's equal to or less than rent, great. If not, then you really got to think hard about whether maintaining this property is in your best interest. And if it's not, or if they do not absolutely qualify for a loan modification, a short sale is the next viable option for them. And a short sale is basically where the lender allows the seller to sell the property for less than what is owed on the note. Basically, the net proceeds are short of what is owed. So short sales are basically selling your house for less than what you owe on the loan. Now, the benefits of a short sale can be many. One, it can help preserve credit. It can help, preserve, I would say, because most people who are in this point their credit's already, pretty thrashed. But it allows them to try to recover and recuperate their credit as much as possible. It prevents a foreclosure and the stigma of a foreclosure, and that's what. And that means a lot to some people. The second is, as I mentioned, avoiding the stigma of a foreclosure. Foreclosures stick with you for a long time, sort of like a bankruptcy. So and it can prevent you from buying houses in the future or leveraging your credit in the future. The third is to take advantage of relocation assistance programs. A lot of banks now have relocation assistance programs that allow them to basically give money to sellers in order to cooperate with them in short selling the house. So sometimes the amount of money that's given can be pretty lucrative, and it's worth the seller's time to take advantage of those relocation assistance programs. Another reason to short sell is to resolve any junior liens that are recourse liens, and what that means is if you have a HELOC or a home equity line or any type of second lien that has any type of recourse provision, which means that the lender can come after you personally for any type of money that is owed on the loan in the case of a foreclosure. Short sales allow you to take advantage of the fact that you can negotiate with them and try to get yourself out of any liability that might still be in place if for some reason a foreclosure were to occur. And the last reason that really helps people to do a short sale is that you might be able to qualify to buy a new house in 3 years through an FHA loan. Right now, the FHA guidelines state that 3 years from the end of a short sale, you could potentially qualify to purchase another home. And that's really important because in 3 years, the market, although it is starting to bounce back a little bit, it still should be at a very low point. I want to talk a little bit more about relocation assistance programs. Relocation assistance programs, depending on the lender, can be extremely lucrative. Take Bank of America. Last year, they had several programs in place. One in particular that allowed them to pay anywhere between $5,000 and $30,000 in relocation assistance for people who cooperated with the cooperative programs there. And so we've been able to successfully procure, $30,000, $25,000, $18,000, $15,000, various amounts of money for people who have agreed to cooperate with the relocation assistance program. So it can be very beneficial for somebody to participate in this program, or at least consider it, when they're in a distress situation. The next thing I want to kind of expand upon a little bit are the recourse loans versus non-recourse loans. And in the state of California, loans that are used to buy your house, to purchase the house, are called purchase money loans. By law, purchase money loans in California are non-recourse loans. And what that basically means is that the lender's only ability to recover on the loan in the event of a default is against the property itself and not against the person. So that means if somebody who has a purchase money loan gets foreclosed on, the lender cannot come after them. Recourse loans are loans where the bank does have a right to come after them. Now, this is really important, especially with junior liens. I think junior liens are really, really important because, excuse me one second. Junior liens are important to take into consideration because if a junior lien is not a purchase money loan, it is typically a recourse loan. Now, recourse loans are interesting because California also has what's called a one-action rule, which means that an investor in property, an investor has the right to either come after you individually. An investor has the right to foreclose or to pursue a deficiency judgment, but not both. So what this means is that second lien holders who are sitting there waiting for something to happen if you're in default, because California also says that they cannot act upon their right to pursue a deficiency judgment until their security interest in the property has been extinguished. So what this means is out-of-position second lien holders are going to have very difficult times recovering their money. So in the event that the first lien holder forecloses, the first lien holder loses their right to pursue a deficiency judgment because they've recovered their interest in the property. However, the second lien holder, their interest has been extinguished, and now they have the right to pursue a deficiency judgment. So that's why if you are in a position where you have a junior lien that is a recourse loan, a short sale is very beneficial to you because that second lien holder is not going away. He's probably going to try to pursue you and either if he obtains a judicial, he's either going to send you to a collection agency and eventually file a lawsuit against you in the hopes of getting a deficiency judgment so that he could try to, garnish your wages or, attach, your bank accounts or put liens on other properties that you might owe. It's a good way to resolve those all at once through a short sale. So that is a big benefit of short selling. The next thing it's really important to talk about is the Debt Forgiveness Act. I cannot tell you how many people approached me and talked to me about this particular issue in December of this last year, because the Mortgage Debt Relief Act of 2007 basically was set to expire on December 31st of 2012. People were panicking. The reason they were panicking is because the Mortgage Debt Relief Act allows homeowners to exclude debt forgiveness income from their taxes and under certain circumstances. And those circumstances are for rate and term refinances or for refinances where the homeowner took cash out but for the exclusive purpose of home improvements. In other words, if you took the money out and put it back into your house, the act still applied. Well, there was a lot of people who were on the hook or could have been on the hook for some big debt forgiveness. And that debt forgiveness also arises through mortgage restructuring. So a lot of the people who are getting principal reductions through the DOJ program, if, let's say, for example, they got their DOJ final loan modification, and it was effective January 1st, that debt forgiveness that they incurred, they could have gotten 1099 on it and been liable for huge debts. So people were panicking and calling me, asking me if they should accept the loan modification, even though it's great. They didn't want to incur, tax liability on $300,000 of forgiven debt. And homeowners were really freaking out about whether or not short sale that they're doing is going to come back and bite them in the end. And as I said, again, this comes down to a very important distinction in California between purchase money loans and non-purchase money loans, because purchase money loans, this law does not really have any effect on purchase money loans, because since purchase money loans are non-recourse, by definition, they have to basically report any loss to the IRS as a zero net gain, so a zero loss. So they really, people who have purchase money loans, this really doesn't apply to them too much. But it really did apply to people who refinanced their loan or took cash out. That is a real big issue with them. So when Congress the reason that there was such a delay in getting this act extended is because it was part of the fiscal cliff. And since Congress was debating on other issues, they couldn't get around to this one. But there was bipartisan support for this. So both parties were really in support of extending it. Now, the one thing that's interesting about it is that one party wanted to extend it for 2 years, one wanted to extend it for 1 year, and they settled on basically extending it for one more year, at least at a time. So, and they'll probably end up reevaluating it. So right now it expires at December 31st of 2013. So it is very, very important that if a homeowner wants to short sell their property, it is crucial that they try to make that decision to do so and not put themselves into that position that a lot of the homeowners were in at the end of this last year, where they were extremely stressed out about the possibility of incurring substantial tax liability that could have been avoided had their short sale closed, let's say a day or two earlier. So that's really, really important consideration. The next thing is I want to talk about is deed in lieu of foreclosure. If for some reason your short sale doesn't work, and there are some instances where a short sale might not work, a deed in lieu of foreclosure is basically another type of remedy that you could use. Now, a deed in lieu of foreclosure is where you basically agree to turn your house back over to the bank. Now, you voluntarily do so outside of foreclosure. Now, typically banks don't use this avenue until you've tried to short sell it first. And so they require typically that you try to market the house for a period of time before you do a deed in lieu of foreclosure. The problem with that is that if you have a junior lien of any type, that usually prohibits you from getting a deed in lieu of foreclosure, because the junior lien has to basically agree to let the other, outside of a foreclosure, let the first lien holder take possession of the house. And since obviously they're not getting anything out of it, they're not just going to voluntarily let that happen. So unless the first lien holder wants to buy out the second lien holder or negotiate some sort of settlement, it's typically not going to happen. So deed in lieu of foreclosures are not something that are very common or necessary in a lot of ways, but there has been some instances where they've had to be done, but in general, it's not an avenue that homeowners, it's basically the last resort before a foreclosure. Does filing a bankruptcy help save your house? The answer to that is probably not. The only way a bankruptcy will help save your house per se is if you're behind on your payments and you can afford the payment that you had before, but you just can't get caught up on the delinquency. A Chapter 13 bankruptcy will allow you, typically, to take the amount that you're in arrears, put it into the part of the trustee payment, and then allow you to start making payments on your house again. The problem is that most homeowners have a problem with their loan, and even if they do that, they're in the same situation they were before. So, because the problem is, not only do you have to make the payment that you were making before, but now you have to make a trustee payment on top of it. And so it creates some sort of problems for homeowners that think that bankruptcy can resolve that problem. And if you want to modify your loan through the bankruptcy, you can try to do so. The problem is they're going to use the same rules that were in place before the bankruptcy. So if you couldn't qualify to to modify your loan prior to a bankruptcy, you probably won't qualify during the bankruptcy, with the exception of a few lenders that are real heavy on debt to income ratios and expense ratios. like PNC and some of the other ones. In those instances, sometimes the Chapter 7 bankruptcy and getting rid of a lot of, unsecured debt will sometimes help you. But in general, it will not save your house per se. The next thing I wanted to kind of go over real briefly is what can I do with the second loan? That's another question that I get posed a lot. Well, I guess the answer to that question is, one, is you can modify that loan. I will tell you that typically lenders don't modify second loans very well. I don't know why that is, but because usually second loans are so out of position, but they don't, especially HELOCs. They don't typically modify them very well. Another thing is that if your second loan is really out of position, you could just really do nothing and let it sit there, knowing, of course, that they have a security interest on your property, and that if for some reason your house ever jumps back into value or equity position, they could come out of nowhere and start a foreclosure proceeding. Or the third thing you could do is you could try to negotiate a settlement with a second lien. You could try to say, I'm going to try to negotiate for 10 to 15 cents on the dollar. So if that, those are the three main ways that people can really try to resolve their second loan. The next thing I wanted to kind of talk about real quick as we come towards the end here is beware of foreclosure rescue scams. Watch out for mailers promising principal reductions. Watch out for people who are telling you about trying to sell you forensic analysis. And watch out for investors promising to buy your house and rent it back to you, and with the promise to sell it back to you within a period of time. All of these types of things should send up real signal flares into your head. Fireworks should be going off. You should really be careful about these types of individuals. When you're in distress, they will bring out the wolves will come, and the sharks will start circling. You'll get so many mailers in your mailbox, it'll drive you nuts. But, beware. A lot of these mailers, just to point out one other thing, a lot of times these mailers will come looking like they're from your lender or looking like they're coming from a government entity when they're really not. And you need to especially be cautious of those types of individuals. Anybody who's trying to kind of trick you into calling them is not worth dealing with. The last thing I kind of wanted to talk about are updates for 2013. And there are a couple updates that are kind of important, one of which we already kind of spoke about. The first is the Mortgage Debt Relief Act, which did get extended as of January 1st through the end of this year. And as we spoke about earlier, that it does carry a lot of value to a lot of people who are either getting principal reductions or wanting to short sell the house. The other thing I wanted to talk about is in California, it's called the Homeowners Bill of Rights. Now, the Homeowners Bill of Rights took effect on January 1st of 2013, basically to ensure fair lending and borrowing practice for California homeowners. And the laws basically are designed to guarantee basic fairness and transparency for homeowners in the foreclosure process. Some of the key provisions of that are there are restrictions on dual track foreclosures. Basically, mortgage servicers can't advance the foreclosure process if the homeowner is working on securing a loan modification. In the past, they could dual track. Basically, they could keep running their foreclosure process while they were processing the loan modification application. And they would, the loan modification department would step in and stop the foreclosure department if it got close. So this particular law in California is kind of, monitoring those servicers on how they're doing that dual tracking. It guarantees you a single point of contact as you try to go through the process. That, I don't know how much value that has. I mean, I guess you just get to talk to one person, but the problem with that is you just take with your CRM. It's usually called your customer relationship manager. Just take what they say with a grain of salt and understand that they do not know how the computer works or how loan modifications work. So just be a little bit cautious about that. The other thing is it has to. There's a provision in there about verification of documents. You know, there's some other things on tenant rights, and you know, there's a lot of different things in this homeowner's bill of rights. But you know, I think the most important feature of that particular law is the dual tracking. So that does help out quite a bit from a loan modification standpoint. So at this time, that's the end of the seminar. If anybody has any questions, I am free for questions.